slow to react. So we're working on that, and please bear with us. Hopefully we can make it a little bit more comfortable. We'll go for probably, an hour and 15 minutes or so, if, depending on where we are in the arguments, before we take a break. I do want to give Sydney a break, probably a couple of hours, or an hour and 15 minutes, hour and a half in, if we need to. So it may be in between replies or whatever that we actually take a break. Trying to think if there's anything else. If you would introduce yourself when you first come up, so Sydney has your name, I would appreciate it. Other than that, one other thing I did want to mention to you. I've read the briefs. They are voluminous. So I have a good idea of your arguments, but that being said, I'm still digesting them. So please keep that in mind as you're arguing. I don't have them memorized, and I'm still trying to figure out all the breadth and depth of your argument. So feel free to educate me as you're arguing. I may have some questions for you as we go through, but it may not too. So one last thing is, you will see during the course of this, I've got all my notes and things on my computer. If I'm not looking at you, I'm looking at my computer for whatever reason, please do not mistake that for me not paying attention. I'm paying very close attention. I'm just, like I said, I do everything primarily in digital format anymore, and so it may be that I'm looking up notes or looking at my next question or what issues I had with a particular argument. The manner in which we're going to go is we'll start with the defendants, and we'll do it in the order of which they were filed, essentially. So the Selzer defendants, or Ms. Selzer, her counsel, and then the register. Then we'll have the replies, I assume, to both, and then we'll come back and loop back around and hear the rebuttals. With that, any questions before we go on the record?
No, Your Honor.
No, Your Honor.
Okay, very well. Let me go ahead and set the record. Are you ready, Sid? We are on the record in the matter of President Donald J. Trump et al. Versus J. Ann Selzer et al. CVCV 069420. This is the time and place set for a hearing on a motion to dismiss in this case. Present here in the courtroom today are counsel for all of the respective parties. Prior to coming on the record today, the court spent a couple of minutes speaking with counsel about just the logistics and the manner in which we were going to proceed, and we are now ready to proceed with oral arguments. As such, I will first turn to counsel for defendant Selzer and allow you to make your argument in this case.
Thank you, Your Honor.
You may proceed.
Thank you. Good morning, Your Honor. I'm Robert Korn-Revere for the defendants J. Ann Selzer.
Yeah, just a second. Let me make sure that you're turned up as best we can. Give me just 1 second. I apologize.
And I'll try and project.
If you can, I would appreciate it. Why don't you try to speak now? If you can, yeah, hopefully that will pick you up a little bit better.
Thank you, Your Honor.
There you go. You may proceed.
Good morning, and may it please the court. I am Robert Korn-Revere for the defendants J. Ann Selzer and Selzer and Company. Your Honor, Ann Selzer is with us in the courtroom today. I want to introduce her. She's as close to counsel table as we could get her, but she is here for the argument. Your Honor, there's an old saying that everything looks like a conspiracy to those who don't know how anything works, and that sums up this case in a nutshell. The plaintiffs here do not understand how election polling works, so they've tried to concoct a case made of a tissue of campaign slogans and conspiracy theories. The issue for this motion is whether any of that adds up to a cognizable legal claim. It doesn't. This is a frivolous case that doesn't belong in this or any court. It's based on a label, fake news, not on any recognized claim. And all the claims are barred both by the First Amendment to the United States Constitution and by Article 1, Section 7 of the Iowa Constitution. And even if not constitutionally barred, these are not valid claims either under the Iowa Consumer Fraud Act or at common law. The plaintiffs here don't even pretend to plead the elements necessary to support their claims. And even if we accept all of the plaintiffs' baseless factual allegations, as one does in a motion to dismiss, all of the claims are barred as a matter of law. This case must be dismissed with prejudice. Now, just to lay out where we're going on this and to save a little bit of time, let me describe our division of labor. I'll be starting with the First Amendment issues. I will talk a little bit about the individual claims from the perspective of the Selzer defendants, but the bulk of the arguments on the Iowa state law claims and the law will be handled by Mr. Kleinfeld.
Okay. Just 1 second, Mr. Kornrever. Do we have the other lapel mic available? I'm going to do something. We're having a difficulty. It's just not picking up quite enough. So I'm going to have Becca give you a different microphone here.
Okay.
If you could put that on your lapel, I would appreciate it. And hopefully that will pick up a little bit better than the one that we have currently. And just ask you to speak up as best you can. I would appreciate it too.
Yeah. Can we take this?
Why don't you, yeah.
But I know, but can we take it away?
Yeah, you can go ahead and take that, Becca. I appreciate it. See if that is.
Is that better, Your Honor?
Is that better, Sydney? I'll turn it up. So I believe it is. So thank you very much, counsel. I appreciate it.
Certainly.
Proceed.
Starting with the constitutional issues. The First Amendment of the Iowa Constitution bar these claims entirely. There's no such thing as a claim for fake news. And the few cases where news is alleged to be fraudulent have all been immediately dismissed. We cited those cases at the beginning of our motion to dismiss, and there's never been a response to them from the plaintiffs. Now, and as a matter of fact, I've been puzzling over what plaintiffs think is their best case, even in support of the theory, in supporting these claims. And I'm still scratching my head, and perhaps Mr. Ostergren will enlighten us during his time on the floor about what they think is their best case. The First Amendment, as the Supreme Court reminded us just this term, is not a word game, and the rights it protects can't be renamed away or nullified simply by mere labels. It is bedrock law that speech is protected unless it falls into a previously recognized unprotected category. And false speech, as a general proposition, is not one of those categories of unprotected speech, and claims that simply allege falsity like that must be promptly dismissed. The claims here are based entirely on three false propositions. First, the plaintiffs claim that election polls are commercial speech because they are done for profit. Secondly, they claim that election polls are not news, protected by the First Amendment. And third, they claim there's no state action here and therefore no First Amendment issue because this is private litigation. These propositions aren't just wrong, they're not even debatable under established law. First of all, unanimous authority holds that for-profit speech doesn't equal commercial speech and is fully protected by the First Amendment.
Let me ask you this, Mr. Kornrever. In your research, have you come across any case law that would indicate a similar fact pattern has been determined to be commercial speech?
No. And as a matter of fact, even the cases that the plaintiffs cite that they say they're commercial speech describe the difference between for-profit speech and commercial speech and say that there are simply no contrary cases.
Now, one of the things that the plaintiff, and I'll ask the plaintiff about this, cited was a Cincinnati case.
Yes.
And that case, at least in part, said that basically anything in a newspaper was considered for profit or for, it implied, I guess, maybe it was potentially commercial speech. It's my understanding, though, that you disagree with that reading of Cincinnati. Is that correct?
I completely disagree with it. As a matter of fact, it completely miscites that case. At page 14 of their resistance brief, they cite that case with the one snippet from the case that says that much of the information in a daily newspaper is commercial. That's right. Newspapers are protected, include advertising. They are for-profit businesses. But the point that the court was making in that case is that nonetheless they are fully protected. The issue in Discovery Networks was whether or not the city could regulate news boxes on the street that were devoted entirely to commercial matter. And the point that the court was making in that statement was that it doesn't matter. You're trying to regulate the placement of news boxes, even daily newspapers that have news in them, have a lot of ads in them. You can't regulate them just because of that. So Discovery Network stands for exactly the opposite of the proposition for which the plaintiffs are citing it. And that's true of the other cases where they cherry pick specific lines from cases talking about commercial speech. The job is a little easier when you get to their claim about whether or not election polls are protected, because they cite no cases to support that proposition. In fact, there are no cases saying that polling is not protected as coverage of an election. We cited the Ninth Circuit case of Daily Herald versus Monroe, and basically the plaintiffs simply cite their own assertions for that proposition.
Other than the Donnelly case, which obviously I assume you'll talk about at some point, is there any other case law involving a free speech challenge to polling in particular?
Yeah, the Daily Herald versus Monroe is one that talks about that. And that's where the court actually discusses why polling is protected by the First Amendment. It's doubly protected because the act of polling involves talking to people to find out what the voter sentiment is, and then publishing the poll is election news. And so there is that. There are very few cases that go into that, by the way, Your Honor, because it's such an obvious proposition that it isn't questioned, and it's no wonder that the plaintiffs didn't have any law to cite there. The third fallacy that they try and use to justify their claims is to say that there's no state action here and therefore the First Amendment doesn't apply. Ironically, they make that statement on the same page of their resistance where they cite New York Times versus Sullivan, which is the paradigmatic case for those kinds of limits on private lawsuits and why the First Amendment applies. And as a matter of fact, that case is comparable here for a variety of reasons, because that case emerged from a campaign by Southern officials to try and close down news coverage of the civil rights movement. And they were trying to use private litigation as the vehicle for doing that. And the Supreme Court emphatically said, no, you can't use those private lawsuits as a way to censor speech. And it established the Sullivan test for defamation, which requires actual malice in the context of defamation. It actually could not be a worse case to reference when saying that there's no state action here. And we cited a number of other cases as well that also reinforce that point. The reference to Sullivan is relevant for another purpose as well, because the plaintiffs here are using essentially the same tactics as in Sullivan, but they're simply trying to use the vehicle of claiming fraud as a way of doing that. That's something that is also foreclosed by the reasoning of Sullivan. For example, the Supreme Court in New York Times versus Sullivan said that the experience the United States had with the Sedition Act described the central meaning of the First Amendment. It first crystallized our national awareness of what the First Amendment means. And what it means is the government doesn't get to penalize false newspapers. That's what that case was entirely about, and what this episode with the Sedition Act was all about. And in fact, when the Supreme Court started formalizing First Amendment jurisprudence in the 20th century, the first case dealing with press freedom was Neer versus Minnesota, where the state was trying to penalize a newspaper called the Saturday Press that was simply described by its detractors as a partisan rag that was nothing but lies and scandal from top to bottom. The Supreme Court said no. Trying to censor even that newspaper was considered to be the essence of censorship. And the court drew the line and established the first major precedent protecting the press. Here, what the plaintiffs are trying to do is to cancel those bedrock rules and say they can simply allege fraud and get around the First Amendment. But as the...
Let me ask you this, and maybe I'm getting ahead of you a little bit, but assuming for a second that I would determine that this was not commercial speech, the First Amendment applies to it, does that dispose of all the claims? I know you've said in your pleadings it's not a matter of immunity, but from a practical standpoint, does it actually extinguish all of the claims?
Well, ultimately it does, but establishing that the First Amendment fully applies is the first major premise here.
Okay.
The second premise is one that was established through case law, again, through the 20th century. Cases saying the exceptions to that rule are few, narrowly defined, and carefully guarded. You can't simply expand the unprotected categories of speech. Plaintiffs make the point that fraud is unprotected speech. Of course it is. That's one of the unprotected categories. But you can't simply call something fraud and make it fall into that category. That's what the Supreme Court said in the Madigan case, that simply labeling that doesn't cancel First Amendment protections, which is what they're trying to do in this case. As Sullivan even said, that you can't simply refer to mere labels of state law as a way around the First Amendment. And even during that period, during the time in which Sullivan was argued, there were attempts in other cases to use state business law to target civil rights organizations. Those were shut down as well because they were being seen as ways to try and bypass First Amendment protections. In terms of trying to redefine fraud, there have been various attempts over the years that we talk about in our pleadings. The key cases that we cite there are United States versus Alvarez and the two Arneson cases from the Eighth Circuit. Those cases explain why you can't simply expand the boundaries of fraud. And most pertinent for this case, they say that you can't expand it to cover election coverage or political speech. Those are the things that the First Amendment protects most. First Amendment protections are at their zenith. And the Alvarez court said trying to expand the definition of fraud would give the government a broad censorial power unprecedented in the Supreme Court's cases or in our constitutional tradition. This was the thing that the courts warned about in terms of expanding what the government tried to do under the Sedition Act. The Ohio Supreme Court in Bertrand versus McMullen said, we need to look no further than the Sedition Act of 1798 to further understand that unscrupulous individuals would use the coercive force of government to censor their critics and retain power. Again, that's exactly what is the attempt here. So far, there has been no real response to the analysis in either Alvarez or in either of the Arneson cases that's saying that you can't just label an action for fraud and hope to carry the day. The court said the alleged fraud, without the essential elements, would support swift dismissal. That's straight from Madigan versus Telemarketing Associates. And the court in Madigan explained why that's so important and why this is a constitutional issue and not just an issue that relates to the individual state law claims that Mr. Kleinfeld will talk about. The court in Madigan said that the exacting proof required to show fraud exists to provide sufficient breathing room for protected speech, and it went through talking about these particular elements and why they are connected to the constitutional protections. The problem here is that even with notice pleading, you can't create a tort that doesn't exist, and you can't create duties that otherwise aren't recognized in law. There can be no misrepresentation in the case from Ann Selzer where there's never been a representation. There's never been any contact between Ann Selzer and any of the plaintiffs. No relationship that would require some sort of duty to them or to the general public. As I say, she's never communicated with them about anything. That, I think, covers the main issues on the First Amendment question. And I'll just say a few things about the state law claims.
Before you do, let me back up and ask you about the commercial speech exception that's being argued by the plaintiff in this case. Obviously, you contend that it doesn't fit into the category of commercial speech. I think you depend on the Central Hudson Gas
Yes.
and Electric case.
Yes.
How does that case distinguish what we have here from commercial speech? What do you hang your hat on in that?
Well, Central Hudson is the 1984 case that defined the commercial speech doctrine and made it clear that the difference between commercial speech and everything else is that commercial speech is speech that does no more than propose a commercial transaction. Essentially, we're talking about advertising, right? We're not talking about, even where a newspaper includes advertising, as the Discovery Networks case made clear, inclusion of financial support through advertising doesn't convert the newspaper to commercial speech.
No, it's my understanding that the plaintiff, and maybe I'm wrong on this, but the plaintiffs have argued essentially the poll was used tantamount to advertising in this case to entice people to buy the paper. Does that deal with the problem of Central Hudson Gas?
No, not at all, because that would extend the commercial speech doctrine to all newspapers, all media that are advertiser supported. The argument can always be made that they are simply putting out whatever they're putting out as a report for the purpose of selling newspapers, for the purpose of generating viewership. But that would simply cancel First Amendment protections. The courts have been quite clear that that isn't sufficient. And even if you've got commercial speech and regular speech interspersed, when it's intermixed that way, is protected as regular speech. And even if you could stretch the definition of commercial speech to apply in this case, which it clearly does not, you would still have to meet the elements of why it's false and why it falls into the category of fraud. And as Madigan explained, those requirements are constitutionally required to provide that First Amendment breathing space. So nothing about this commercial speech argument is remotely close to the mark.
So when you say the requirements of Madigan, you're referring to the requirements of malice, is that in particular?
No, that would be in the defamation category. Those were the requirements established by the Supreme Court in New York Times versus Sullivan, which is the specific standard for defamation. Right. And I should say, the court in Alvarez went through and said, you can't mix and match these theories. You can't say we're going to cite a few lines from defamation cases and then apply them to false statements generally. You can't take a few lines from fraud cases and then expand that to expand the category of fraud. The court has been quite emphatic about how startling and dangerous it is if you go about the business of trying to redefine or expand those existing categories.
Very well. Tell me about the state claims, or to the extent...
Yeah, just a few words on that, because Mr. Kleinfeld is going to be covering that in the main. The Iowa Consumer Fraud Act claim, I mean, it is a claim that fails at the threshold because political polling, election polling, is not commercial merchandise within the meaning of the law. That merchandise, according to Iowa Code 714H2, is merchandise offered for sale or lease, sold or leased, primarily for personal, family, or household purposes. That's not an election poll. So right out of the gate, that claim fails. We say in our papers the other reasons why it simply doesn't apply to this situation. But once you break that nexus, the law doesn't apply and should be dismissed under well-established law, even under notice pleading. The fraudulent misrepresentation claim, we showed how the plaintiffs even failed to allege facts for 6 of the 8 required elements of fraudulent misrepresentation. But the main problem is that plaintiffs misunderstand fraud as a concept. It requires a false statement intended to persuade the plaintiff to part with money, property, value in reliance on the statement. Nothing about Selzer poll falls into that category. And again, as I mentioned, there has been no allegation that the Iowa poll was material to any claims or being used to induce any reliance on the part of the plaintiffs. The negligent misrepresentation claim also fails at the gate because there's no duty between a pollster and anyone else other than the people she contracts with. No one among the plaintiffs went to her for advice. She didn't provide them with advice. The negligent misrepresentation is simply a shoe that doesn't fit. And we cited a number of cases saying that general news reports don't create a duty to the audience. So there's really nothing there.
To the extent I've done some research, one of the areas I looked at was similar case law involving claims of weather, misrepresentation, things like that. It's my understanding, and correct me if I'm wrong, that to the extent that there's a duty, the duty is to generally the public and not to a specific individual, is what those cases often come down on. Is that correct?
That's partly true, Your Honor. And the main case I think you may be referring to is Brent versus Weather Channel, which was the case from the Southern District of Florida where someone brought a wrongful death action against the Weather Channel saying that the forecast was wrong and therefore someone was killed at sea, and as a result the Weather Channel was responsible for not providing accurate weather forecasts. Actually, it's a very close analogy to talking about election polling. And the court said a couple of things. One, that the duty simply did not exist, and for that reason it broke any possibility of liability in that case. But it went on to say that if you tried to impose a duty on the weathercaster to the audience, that would create unlimited liability. And so it was absurd as a concept, and that it would violate the First Amendment to try and interpret it that way.
So those cases do, though, at least in part, deal with First Amendment claims.
They do, because they deal with the substance of the claim to begin with and conclude uniformly that there is no duty and can't be enforced in the media context like this. But they also say, as sort of an additional part of the reasoning, is that if you were to interpret a duty in that way, it would be an intolerable burden under the First Amendment.
Okay, very well.
The last thing I'll talk about, Your Honor, is that we requested for the court to compel the plaintiffs to show cause why there are or are not in compliance with Rule 1.413.1 of the Iowa Rules of Civil Procedure. We've tried to explain that this is a frivolous case from the beginning. We briefed, as you may recall from the stay hearing in January, the many frivolous cases in which the lead plaintiff has been involved. We pointed out in our motion to dismiss that they have yet to name a single case that supports this theory. We predicted at the time that by the time we reached today, we would still not see a single case that supports their theory.
Is that where you hang? Well, let me ask you this. What can you say, or do you believe that this is a good faith extension of the law as it currently reads?
No, and that's why we devoted a section of our motion to dismiss to say that there hasn't been any argument for extending the law here. And that was the point that the Iowa Supreme Court made in Barnhill versus District Court of Polk County, where it said that even in notice pleading, there comes a time when lawyers have to acknowledge what the controlling precedent is with candor and honesty, while asserting reasons to modify or change the law. There's never been any argument by the plaintiffs that this court should change the law. They're simply trying to say, in their view, what the law is, contrary to unassailable precedent. And what is more maddening about that is that we have asked for explanations and have gotten none. We have pointed out that there are no contrary cases on this theory of commercial speech, and no response to that. And it would be bad enough if that were just happening in the case post June 30th of last year when the complaint was filed in this court. But as Your Honor knows from the previous history in federal court, these same arguments were made over a year and a half ago. And there was briefing exchange between the parties. The plaintiffs are well aware of this authority and yet simply don't respond to it. So our suggestion is that as members of the bar, we owe a duty, and we are Not asking the court to issue sanctions at this point. We're asking the court to require an explanation for how any of this can be consistent with Rule 413.1 of the Rules of Civil Procedure.
Thank you very much.
Thank you,
Mr.
Your Honor.
That, we'll turn to Mr. Kleinfeld. Mr. Kleinfeld, two things. Make sure that microphone, put it on your tie if you can. I think it comes in a little bit better. And also, I forgot to mention this about this courtroom. Unfortunately, we can't cover up the windows at the very top, and so there's the spotlight often will hit you right in the face. If you need to move a little forward, move a little back to get out of the sun, please feel free. That's pretty bright. Yeah, it's kind of a brutal part of this courtroom. But yeah, whenever you're ready then, Mr. Kleinfeld. I think you should be able to push that forward if you need to, or push it back, whatever.
Good morning, Your Honor.
Good morning.
My name is Nick Kleinfeld. I'm here on behalf of the Des Moines Register and USA Today. Along with me are my colleagues David Yoshimura and Carolyn Gunkel and the rest of the Fagery Drinker team. And importantly, also along with us is Ed Larkin, who's the Chief Litigation Officer for USA Today. Your Honor, I would first like to report that the death of the motion to dismiss in Iowa has been greatly exaggerated. I went back and checked the book that the law firm provides me every year, the Iowa Rules of Court. Sure enough, it's still there, 1421F. The following defenses or matters may be raised in a pre-answer motion, failure to state a claim upon which relief may be granted. Not only does the rule still exist, but it gets used. As we've cited for Your Honor, I think we've cited almost 12.5 cases. Our hands eventually got sore from citing the cases. We left some off. And the standard is clear. The standard is this: the claims must be dismissed if they are legally deficient and plaintiffs have no right of recovery as a matter of law. Plaintiffs rely here a lot on notice pleading, and we understand that's important. But what's also important to understand is that we've been at this now for over 1.5 years, as Your Honor is painfully aware. This lawsuit was originally filed right after the 2024 election. We are now approaching upon the next election. The petition, in some form or another, has effectively been filed in 3 different cases. And we have 42 pages of alleged facts. So we know what those are. We have 50 pages of briefing from counsel and their resistance. And so we know what the alleged legal support is. And the problem here is that there can be no notice of a claim when there is not a valid legal claim to be had. There's simply no notice of valid legal claims here, even if everything plaintiffs said are true, which I know is the standard. They still cannot allege a legally valid claim. Many of the cases that plaintiffs cite on their notice pleading argument really deal with factual disputes. I don't have enough facts. You haven't filled in enough blanks. I dispute the facts. And certainly while we would ultimately disagree with some of the facts they allege, that's not the purpose of this motion, and that's not what we're here to talk about. What we're here to talk about is assuming everything they say is true, there can be no valid legal claim.
Let me ask you, before you launch into it, Mr. Kleinfeld, let me ask you a couple of questions. One, it's my understanding, and I think you brief on this, that the Supreme Court in Iowa has rejected the Iqbal Twombly analysis that federal courts use, correct?
Correct.
Strikes me as the Donnelly case, Judge Ebinger in that case, put a fair amount of weight on the Iqbal-Twombly analysis in coming to her conclusions on the dismissal of, which are very similar cases or similar situations as here. Is that a correct statement?
Well, Your Honor, I think that there's really only kind of one issue where she may have relied on the plausibility standard, and that is, and I believe my colleague here has pointed out, regarding the Pearson article.
Okay.
And
she
rejecting
disregarded
that.
the Pearson article, correct?
She did. She rejected it because she said that it didn't have a valid factual predicate.
And
That
she-
it didn't make sense.
And she hung her hat on the Iqbal-Twombly standard in doing so?
She certainly seemed to indicate that that was part of it, but there are other reasons to disregard that.
Okay.
And again, that's not vital to our argument. We raise it in our brief because we take objection to that accusation that the poll was manipulated or manufactured in some way. It's rank speculation. I'd rather we cite cases in our brief that you can't simply, reference in a footnote to your brief and then kind of indirectly rely on it. In other words, they say the poll is fake. And so there's other reasons besides the one which Ebinger relied on to disregard that factual allegation. And we would suggest that Your Honor should disregard that factual allegation. But I believe that's the only time she relied on it.
Let me ask you kind of a different question before you get too far into your arguments on the notice standard. One of the things, and I'm not sure if it was the Selzer defendants or you that kind of implied that we should kind of take a fresh look at the motion to dismiss standard under 1.421 with the advent of Iowa Code Section 652.1, which is the anti-SLAPP legislation. That gives us some indication of the public policy that the legislature is wishing to promote. Do you believe a higher standard is required currently in a case of this nature, given the fact that there is both the First Amendment issues relevant and the new kind of public policy argument that has come about because of this anti-SLAPP legislation?
We think it can and should inform the court, Your Honor, but we want to be clear. We know it doesn't apply here because the plaintiffs filed their lawsuit the day before it took effect. We understand that the anti-SLAPP statute has changed kind of the notice pleading standard there for those cases. But I think what remains is that the legislature has clearly indicated a policy preference to be very cautious in lawsuits like this. And now there's a system set up. The anti-SLAPP statute sets up a system for this. But it highlights the danger of these kinds of cases. Luckily here, we don't need that higher standard. We're just fine on the notice pleading standard because this is not a fact case, it's a law case. And what you'll notice throughout, and my colleague, Mr. Cohen-Revere, mentioned this, what you'll notice throughout here is a couple of themes, Your Honor. There's a mixing and matching of elements that plaintiffs do, where they'll kind of ignore some things or they'll separate an element. They'll try to rewrite the element. The second thing you'll notice is a lack of case law. Just as Mr. Cohen-Revere pointed out regarding the First Amendment, you'll notice that in their ICFA section, there are 0 cases they cite in support of their ICFA argument. In support of the fraudulent representation claim, 0 cases. In support of the negligent representation claim, they cite a couple of cases regarding the standard that we'll talk about, but it's not really in support of their case. So I know we've thrown a lot at Your Honor in terms of briefing, and Your Honor has been very gracious in in his schedule, and I know we just filed our reply brief on Monday, and that was voluminous. You know, this is an important lawsuit. It's a lawsuit by the President of the United States against the largest newspaper in the country, and we take it very seriously. And so today, I'd like to be as practical as I can be, and make it as simple as I can be. With regard to the First Amendment, I'll simply say this. I think Mr. Cornevere has covered it. I think we've covered it in our brief. It appears that plaintiffs have settled on a commercial speech theory. Mr. Cornevere has explained why it's not commercial speech. But that's the theory they've settled on. And so if that were true, if it were commercial speech, if plaintiffs were to win on that issue, the problem is they then turn the page and they forget that analysis in their arguments on the claims. And here's what I mean. That if plaintiffs were correct and this was a commercial speech case, then under the Cincinnati case, they would be limited in terms of the act that they're suing about to something that is solely a proposal for a commercial transaction. That's it. But they forget that in the rest of their analysis. And so I'll talk about first the ICFA claim, and in trying to make that as simple as I can, here's what I'll do. I'll just talk about what's the requirement, what are the allegations, and what are the reasons why it's not legally viable. There are really sort of four essential elements of an ICFA claim. And I know there has not been a lot of case law on the private right of action under ICFA because it just came into effect in 2009. And as your Honor knows, our Supreme Court has identified that the state of Iowa adopted their statute based on Illinois statute, and the Supreme Court's told us to look to Illinois for guidance in terms of case law, which is really helpful here because one of the cases that your Honor can look to, and that we cite in our brief when we talk about the reliance argument, element that plaintiff's claim doesn't exist, is the triplex case. And on page 461, 462, it lays out the elements. The Illinois Supreme Court does. And it says the elements are as follows. You have to first have a deceptive act or practice by the defendant. Second, the defendants intend that the plaintiffs rely on the deception. Third, the occurrence of the deception in the course of the conduct involving trade or commerce. 4, actual damages to the plaintiff. And 5, that those damages were approximately caused by the deception. First, let's talk about the act. The act that's alleged here, Your Honor, is there's several theories that you can go under ICFA. Plaintiffs have chosen 2, unfair practice and deception. And what they allege is the publication of the Iowa poll. Plaintiffs also argue that, well, it's not just the publication of the Iowa poll, but we sort of speculate that it was manipulated or manufactured in some way. But it's the Iowa poll. Here's the reasons why that's not legally viable, and why there's no pleading, there's no discovery, there's nothing that's going to change this. First, the Iowa poll is not an unscrupulous business practice, which is kind of the phrase that the Iowa courts have used to describe an unfair practice. With regard to deception, it doesn't involve a false statement of fact we cite plenty of cases that it's a poll, it's a scientific opinion, it's not a statement of fact. And in other words, it's not a statement of fact, but it's not as required for deception, a statement of fact regarding something that's material to a consumer transaction, right? You think of price or things like that, quality, so forth. That's not being alleged, and it cannot be alleged. And as we talked about, we don't believe Your Honor should accept this allegation of manipulated or manufactured, but again, even if Your Honor doesn't matter, there's still no claim. The second element is intent. And this starts out kind of the mixing and matching and rewriting of law. Here's the actual requirement. Press defendants, they have to prove that press defendants intended the act to be relied upon by plaintiffs in connection with the sale or advertisement of consumer merchandise. So they allege that, well, the intent was drumming up political support for Democrats. Here's the reasons why that's not legally viable. First, let's just talk about sale or advertisement for a minute, because I know Your Honor asked about advertisement. They've effectively disavowed advertisement. If it talks about advertisement, sale, or lease, clearly we were never talking about a lease here. Plaintiffs just rely on sale. They're not saying we advertised anything. There again, under Cincinnati, you have a First Amendment problem. But just with respect to the sale, they didn't sell anything to these plaintiffs. And you'd have a First Amendment problem because it's not a proposal for a consumer transaction. Second, let's talk about consumer merchandise, because that's another piece of this element. As we pointed out in our opening brief, plaintiffs took a definition of consumer and a definition of merchandise and ignored the definition of consumer merchandise. And that was really important because in doing so, they read consumer transaction, consumer, anything to do with consumers completely out of the statute. Because the way that the private action is written identifies consumers as just a natural person. And then identifies consumer merchandise, as Mr. Cornevere explained, something primarily for personal household use. They excised that out of it and said, well, Donald Trump is a person, okay, and the newspaper was merchandise. But they didn't talk about consumer merchandise, which is the heart and soul of the Iowa Consumer Fraud Act.
Under the definition that the plaintiffs advance, Mr. Kleinfeld, wouldn't virtually every podcast, every paper, every magazine fall under that definition?
Yes, and importantly so, you would rip apart the essential fabric of ICFA because ICFA is about protecting consumers. It's not about business-to-business disputes.
And you contend that there needs to be at least some degree of reliance or personal reliance on it as well. Is that correct?
Yes, and that's again a separate element. But before we get to reliance on the intent, what they do is say, okay, we've talked about sale, we've talked about consumer merchandise, but again, remember that the element is that press defendants intended the act to be relied upon by plaintiffs in connection with the sale or advertisement of consumer merchandise. And so here's what they do. Very much like how they split up consumer and merchandise, what they do is they split that element writ large up as well. So they say, well, let's split it into two parts. Intent, others rely on the act. And then separately talk about the act was in connection with the sale of consumer merchandise. They bypassed the through line. And so then they say, well, intent, others rely on the act, political support. That was it. The people relied on it, for political reasons. Nothing to do with consumer transaction. That's not what it's about. And then with respect to the act was in connection with the sale of consumer merchandise, they said, well, a general circulation newspaper can be consumer merchandise, and sure it can. It wasn't here, and as the case law we talk about, you have to actually look at the reason why somebody bought it here, but they completely bypassed the through line. They are not alleging that we did something that they relied on to purchase the Iowa Poll or the Des Moines Register. That's completely disavowed. And that is the requirement. Third, reliance. This is where it gets a little easier, Your Honor, because they just say, well, reliance isn't required. And so we don't really have to say anything about that. To the extent that we do, all they say is polls can have impacts on elections.
No, I do want to make sure, though, to the extent that you're finding or arguing that the reliance issue is an element of the claim, that's based upon essentially the Illinois case law, is my kind of understanding. Is there any Iowa case law that deals with the personal reliance element of that statute that you're aware of?
Your Honor, I don't know that it's been disputed in courts, but here's what I would add. I'm glad Your Honor asked about that. Because in addition to the Illinois case, which makes it clear, and they explain why, and part of the things they point to, and I'll point it out with respect to Iowa law, is how the statute's constructed. And what you do is you start out with kind of a presumption of common law requirements, intent, reliance, damages. And then when Iowa came and passed the original Iowa Consumer Fraud Act, because of the nature of it, and because it was solely enforceable by the Iowa Attorney General, they made it different. And they made it very, very clear. When you compare 714.16.2a with 714H3, right, the kind of the two, the AG statute and the private right of action statute, when you compare those two, they're starkly different. And the Iowa legislature in the AG statute, which was the one that was first enacted, made it very clear that it was disavowing certain common law elements, such as intent and reliance and damages. And the reason is very clear. So I'm sure Your Honor's had cases. The Attorney General actually has the power to come in before somebody's been harmed, regardless if a consumer has actually went ahead and relied on an act. And even if the defendant may not have intended what was to occur, because they come in and they can get injunctions and different kind of equitable relief. And that makes sense. They're an elected official, and that's part of their function. But when the Iowa legislature enacted the private right of action, it didn't do that. It left all of those elements in. And it's also made clear, Your Honor, by the relief sections, where the private right of action says there's got to be actual damages. And they have to result from the act. Not just the act, but the act that violates the statute. So the Illinois Supreme Court took the same language, and they said that's a proximate cause requirement. And that means you got to rely on it. And indeed, it wouldn't make any sense. If you didn't have a reliance argument, then this really, we kind of joked in our brief it would make it the Iowa Fraud Act and not the Iowa Consumer Fraud Act. It really is worse than that. It would just make it a freestanding grievance statute. Then you get to damages, Your Honor. And this is important not only because it's an element of the claim. I mean, often we don't think about damages till later, but it goes to show the reason they're suing, and it kind of sheds light on the rest of the elements. And ICFA, the private right of action, is limited to actual damages that are an ascertainable loss of money or property.
From the transaction itself, correct?
From the transaction itself.
Okay.
And so it's designed for people to go get their money back. And when they were fraudulently induced into a transaction that they shouldn't have been induced into.
No, let me ask you this. The difficulty, I'll be honest with you, that we run into in this case is the current procedural posture that we're dealing with it in. Is there sufficient pleading or lack thereof to allow this court to dismiss it on a motion for summary judgment, or is this the matter of damages really an issue that has to be dealt with on a summary judgment phase, not a motion to dismiss? I don't know if that makes sense, but.
Yeah, I'm glad Your Honor asked that. And it can easily be dealt with and should be dealt with on a motion to dismiss standard, and here's why. Plaintiffs have been very clear about what their damages are and what they are not. They've been very clear that our damages are the time and resources to mitigate the influence of the Iowa poll on the electorate. Here's the problem with that. First, ICFA does not provide for consequential damages. You don't get mitigation damages. And you cannot bring a claim for contributions to a campaign or on behalf of a campaign, which is a separate legal entity, or losses by other third parties.
Is that because of the definition of a consumer under the statute? Is that where you hang your hat?
Well, ICFA makes clear that
And let me just ask you this while you're thinking about that, because the difficulty I guess I have in interpreting that any of the damages that were sustained, even if the plaintiff were allowed to amend to assert a claim based upon the campaign itself, consumer is defined in 714H.2 as a natural person or that person's legal representative. I don't think a campaign would fit into either one of those.
it would not.
So to the extent that there are any damages, they have to be damages that are actually incurred by the personal plaintiffs in this case, correct?
Exactly.
Based upon the transaction of buying the register to the extent they bought it, correct?
Correct.
And in the pleadings itself, it only indicates that only maybe plaintiff Miller Meeks was even one of the buyers of the register. Is that a correct statement?
That's absolutely correct, Your Honor. And importantly, the petition also makes clear that Representative Miller Meeks did not rely on the Iowa poll in purchasing it. That's not why she is a subscriber to the Des Moines Register. It had nothing to do with that, right? She just happened to be a subscriber of the Des Moines Register, and that's important. And so what they've alleged not only is insufficient, but more than that, it makes clear that there can be no set of conceivable facts that would result in damages or any of the other elements. It just can't happen, right? We know who the plaintiffs are. They're three individuals, right? We know that it's about the Iowa poll. There are no set of conceivable facts that are going to meet these elements. Next, Your Honor, I will briefly talk about fraudulent misrepresentation and negligent misrepresentation. The three issues that I think are easiest to deal with on fraudulent misrepresentation are first, that the poll is a non-actionable statement of opinion. You have to have a statement of fact, something that's capable of being proved true or false. Clear that a poll cannot be proven true or false. An opinion can't be false. Plaintiffs don't really engage with that in their brief. There's no justifiable reliance that they allege or can allege here because they completely disavow it. They pled themselves out of court, Your Honor. They completely disavowed that. President Trump was very clear that he thought this was fake from the beginning. Lastly, redressable damages. Again, damages don't fit here. It's a little bit different damages that are provided under fraudulent misrepresentation. You're limited to out-of-pocket damages or benefit of the bargain. They're not claiming benefit of the bargain. They say, hey, well, I think we have out-of-pocket damages. But the problem with that is it's limited to a loss suffered as a result of recipients' reliance upon the misrepresentation. Again, they're not claiming that they're being damaged because they bought a newspaper here.
One of the things, Mr. Kleinfeld, and enlighten me if you know otherwise, but I couldn't find, in looking at these cases that were cited, it appears that most of them were postured in a motion for summary judgment phase or trial or whatever, but I couldn't find any that, at least in my research, indicated that it was amenable to a dismissal at a motion to dismiss phase. And are you aware of any cases that support an action that early in the case?
Well, I think we truly have a unique set of facts here, Your Honor. And I think this is very similar to the ICFA situation, because it's a similar theory, right? It's fraud. And where you've made clear that there's no way you can meet an element, it shouldn't matter, right? And so for the same reasons why motion to dismiss is appropriate in an ICFA case, it's appropriate in a fraudulent misrepresentation case. The even easier one, of course, is negligent misrepresentation. And the only element I'll focus on here, because we focused on the rest in our briefs, is, as Mr. Cornevere pointed out, the Weather Channel case. I mean, there's no duty between the parties in this case that would result in a negligent misrepresentation case.
Let me ask you this. It's my understanding and recollection, and trying cases of this nature for a number of years, that negligent misrepresentation is pretty narrowly defined to just a handful of group of folks that would fit into that advisory capacity issue. Is that correct?
Absolutely, Your Honor.
Attorneys, maybe accountants, maybe some engineers, but even that is not, I think, a straightforward thing. Do you have any indication that there's any case law that would support a similar fact pattern to what we have here, where a court has allowed a case like this to go forward?
No, we have not found one. Plaintiffs have not found one. And so, and again, that makes sense because it would certainly be a perverse result, because, it would mean pollsters would be subject to liability to anybody who happened to read the poll. It would mean that, people who forecast the weather would be liable to anybody who watched the news. It simply wouldn't make sense. Lastly, on the federal case, Judge Ebinger, we would simply say this, Your Honor. That is extremely strong precedent. We don't think Your Honor needs to necessarily get into whether it was precluded, there's an issue preclusion there or not. Judge Ebinger was clear on how she defined the case. She described it as brought on behalf of all Des Moines Register subscribers, asserting this mistaken poll as quote-unquote fake news, constituting fraud upon the entire punitive class. Two things I think are important about that is the Donnelly case was purportedly about consumer harm. It was kind of the classic case. You come in, I think there's consumer harm, class action, and everyone said, no, there's no claim here based on the Iowa poll. The second thing is, in terms of this being uniquely strong presidential authority, is these cases were filed within weeks of each other. It indicates that maybe Donnelly let President Trump file this case first, then Donnelly comes, or whatever. Donnelly tried to even file his lawyer tried to file an amicus brief in favor of Trump on one issue. But the bottom line is it's the same defendants, same claims, same issues, same judge. And both motions in this were briefed up before the decision on Donnelly. And of course, the judge noted they were related, and so she dismissed all those claims with prejudice. And for those reasons, Your Honor, for all the reasons that I've mentioned here this morning, we request that the court dismiss plaintiff's lawsuit with prejudice.
Very well. Thank you. Before I turn to you, Mr. Ostergren, I think why don't we go ahead and take a break. Before I do, Mr. Revere, I was mispronouncing your name. I apologize. I totally messed it up, so please forgive me. But why don't we go ahead and take a break? We'll come back on the record at 20 after the hour, and we'll pick back up at that time with Mr. Ostergren's arguments. Thank you, folks.
Check, check, there it is. Check, 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 1, 2, 3. There we go.
Testing, 1, 2, 3. Test, 1, 2, 3. 1, 2, 3.
I still need,
before I don't think you need that, Mr. Ostergren. Hopefully, the microphone there on the, if you want to talk into it real quick, make sure that it does work, but I think that'll pick you up a little bit better.
hello? Hello?
I think that's just a little bit better. Here, let me make sure. Now, try it now.
Hello? Check?
Can you hear okay, Sid?
Yes.
Okay. That's awesome. And my understanding is, before we go on the record too, apparently the air conditioner was shut off in here. So, and I don't know why, so we fixed that supposedly. So hopefully it'll be coming down a little bit. Is it?
The fiscal year just started, Judge. Of course, you have plenty of money for
Exactly.
air
I don't know if
conditioning.
we're off the record, but I don't know if you remember, if you tried any cases here before the rehab of the courtroom, or the courthouse. We used to have several courtrooms on this floor that you couldn't run both the air conditioner and have testimony at the same time because they were too loud. So we would actually drop the temperature to like 65, turn off the air conditioner, call a witness. It'd get up to about 80. We'd take a break and turn around. And do it again.
I remember this courthouse when I interned in the Polk County Attorney's Office in spring of '97, and it was a unique place with all court functions in one building.
Thankfully, the Polk County has done a wonderful job of rehabbing this building, and they've fixed almost all of those problems. But apparently, we had the air conditioner shut off in here. So anyway, with that, Sid, are you ready? We will go back on the record, and I will turn to counsel for the plaintiff. You may proceed, Mr. Ostergren.
Thank you, Your Honor. I want to emphasize, as the court knows, that notice pleading is Iowa's rule. Defendants expressly or impliedly rely on the federal pleading standards in their arguments. They want to be enrolled with Iqbal and Twombly, but they are not. The pleading standards in those cases have been repeatedly, expressly, and emphatically rejected by the Iowa Supreme Court. The law is that all we have to do is put the defendants on notice about why they are being sued. And based on their motion papers and the comments of counsel, they clearly understand why they are being sued. That satisfies the standard for a motion to dismiss.
But just before you get too far, but you would agree with me under 1.421F, they still have to, it still has to articulate the claims, the elements of the claim, correct?
The Terrace Hill Foundation case answers that question in the negative, Your Honor, and it makes clear that petition does not even have to fully specify the legal theory upon which it is based. That's a recent Iowa Supreme Court case dealing with notice pleading standards. Now, it is true it is possible for a plaintiff to plead himself out of court. That's what the cases say. But this happens when a plaintiff has made allegations that conclusively show he has no right to recovery. A good example would be a petition that clearly shows the case has been brought beyond the statute of limitations. A case that I'm litigating right now where a plaintiff has filed a petition for writ of certiorari to challenge a decision of a board of supervisors acting in their legislative capacity, where, of course, certiorari will not reach that. That is pleading yourself out of court, but that is not what has happened here. My friends have made arguments that would be very well done if we were here arguing a motion for summary judgment. Almost every single thing that they said, and frankly, almost every question that Your Honor asked, inherently depended on understanding what the facts are, not what the petition says, but what the facts are. And if at some point in the future we're back in this court and counsel have a stack of motion papers at the summary judgment stage, then we can meaningfully talk about whether there is a jury question here. But until we get to that point, almost anything that has been asserted cannot be resolved at a motion to dismiss stage.
Do you believe that that is even the case when there is an issue of First Amendment import? In other words, I guess one of the things that I struggle with in this case is the tension between that notice pleading and to what extent the First Amendment gives you protection. It seems like there'd be a massive chilling effect if any case is allowed to get past the motion to dismiss phase for a defendant of this nature. How do I resolve that tension between the two, the First Amendment and the notice pleading?
Well, I think it's an insightful point, Your Honor, and we've had references to our new anti-SLAPP law. And I have a couple points on that I think address your question. If I haven't, please follow up with me and keep me honest on that point. First of all, in some of the motion papers earlier, there's been some complaining from the defendants that this lawsuit was filed before the anti-SLAPP law went into effect. Although later they want to have their cake and eat it too, if that's I think maybe a mixed metaphor there, but they want the court to import some anti-SLAPP reasoning into a case where the statute doesn't apply. But for all the complaining that this lawsuit was filed before the anti-SLAPP statute went into effect, it's interesting that essentially, according to the defendants here, that anti-SLAPP law was completely unnecessary, because they say all of these cases can be resolved without the anti-SLAPP law being in effect, because the First Amendment can be waived about, and then the plaintiff is kicked out of court. And let's think about what the anti-SLAPP statute does. The anti-SLAPP statute does not change the notice pleading standards in our state. The anti-SLAPP statute says that a defendant in certain kinds of cases can conduct discovery early and in a limited fashion on the issues that would drill down on First Amendment as an overarching legal principle touching certain areas of the common law or statutory law. And then you have a motion for expedited relief, which is essentially an early, quick summary judgment process, and then a right for appeal based on the district court's denial of such an early motion. There's nothing in the anti-SLAPP law, which of course does not apply to this lawsuit, that purports to change notice pleading standards. It simply flips the normal process of how discovery and motion practice works in certain kinds of cases. And so, Your Honor is correct. The First Amendment is an important thing. We believe that too. But it doesn't just simply eradicate common law theories of fraud, statutory theories that are built on fraud, and the First Amendment itself does not protect certain kinds of speech, and fraud is one of them. And we can't know the extent to which that exception applies until the parties have conducted discovery. That exemption, I shouldn't say exemption from the First Amendment or exception, the First Amendment, the freedom of speech that it protects does not include certain kinds of things like fraud and true threats as examples.
Let me ask you this while you're on that subject in particular. What further facts would needed to be developed during the course of discovery? Or as I take the defendants in this case, they are contending, hey, this is all just a matter of law. There really aren't necessary facts that need to be decided. What, in your estimation, are the facts that need to be developed in the course of discovery?
Well, we need to know how the poll was conducted, whether a poll was conducted. We take it on just the simple assertion from the defendants that this was actually calling people and asking their views. What was the process when these flawed numbers were being considered and vetted? What was known and understood by the various participants in that publication process about the possibility that these numbers could be real? What decisions were made about going ahead in the face of information that was so utterly implausible that it defies belief, that it could be anything other than deliberate misconduct. Just to name a few. Those are all things that we have to know before the court can start applying these doctrines. Much of this sort of just has happened in the vacuum as to what the court thinks the case is about. And respectfully, the court can't know that yet until we have a fully developed summary judgment record to see if there's issues that are in dispute. And I suspect there's going to be a lot of issues in dispute, and that means 8 Iowans are going to sit in that box and decide, not the court.
But from your standpoint, the 421, there is no heightened standard that should ever be applied in a situation where the First Amendment is at play under 421.
Not at a motion to dismiss stage under the law that applies to this case. And even if we were in an anti-SLAPP procedure, the remedy for that is early discovery on those questions and an early determination as to what facts are there so the court can apply these doctrines with the First Amendment sensibility, I'll call it, that overarches how the court analyzes those things. So even in anti-SLAPP world, the court can't just dismiss a case and say, oh, well, the First Amendment. If that's true, our law would be media organizations are immune from suit. They have sovereign immunity, essentially.
No, it's my understanding you're proceeding under an argument that this speech was commercial speech. What discovery would be needed to flush out the issues relative to that? I mean, it appears that it's all in the pleadings.
Well, I think the discovery would flesh out, much like I said before, was this actual polling that occurred? Or is it just contrived? That would be one aspect of it. Everything that led up to the commissioning, if the poll actually happened, if it did, how it was conducted, what data was presented, what assumptions were made in the process to reweigh the populations that were sampled. There's things that are done in that process in legitimate polling that can turn things into just fabrications. And so that just scratches the surface of what will have to be learned in order to understand, does this fit within a commercial speech doctrine, or is this just some statement of opinion or that's protected by the First Amendment? We can't know that until we have gone through the discovery process, and then the court can be presented with a summary judgment record and decide, are there fact issues that have to be tried?
Okay, you've referred to the commercial speech, and I want to drill down on that. I may be getting ahead of where your presentation, I apologize, but while I'm thinking about it, I want to ask you. The argument that I understand you're making as far as this being commercial speech is, as I can tell, there's not a lot of support. It seems fairly unprecedented, for lack of a better way of putting it. Are you aware of any cases nationally, state-wise, that would give us a good direction that a poll of this nature would be considered commercial speech?
Well, I will readily admit that there is a certain novelty to the claim that we are pursuing. As Mr. Kleinfeld, quite frankly, said himself, that this is a historic manipulation by a news organization, in our view, of abusing its position and putting a product out into the market on the eve of a highly contested election, which all indications show was fabricated or to the point of such colossal mistake upon mistake upon mistake and then pushed out the door that becomes misconduct. And I don't know of anything like that that's ever happened in the history of our political and media system in that exact way. And so, yeah, there are novel questions of law and fact that have to be explored.
Good. But you believe that those novel questions are ones that require a matter of discovery and can't be resolved at this issue, at this juncture.
And it's not just that I believe that, Your Honor. The Iowa Supreme Court has, frankly, warned defendants and respectfully warned district courts over and over and over about trying to run your court and file motions to dismiss or granting motions to dismiss and causing an unnecessary appeal where, I mean, you know, Your Honor has read those cases too, where the Supreme Court sends it right back and says, no, we meant what we said about notice pleading. Now start this process and go through discovery and find out what the facts are.
In the normal course of a car accident or a malpractice case, I would totally agree with you, but this case strikes me, it sits much different than a normal case because of the First Amendment implications, because of the procedural posture that it took before coming to this court. It gives me pause as to whether the normal course of application of 1.421 subparagraph F would apply in that just a bare bones pleading is required. Specifically, because of the massive, just say it, massive First Amendment implications that are here, there is an element of chilling, and there is an element of that would come with that require, I think, portain and indicate that I should take a closer look than just the normal malpractice case. Is that, am I wrong on that? Maybe, and we're going around in circles, I don't know.
Your Honor, respectfully, that sentiment doesn't come with, as the Iowa Supreme Court said in Doe versus Smith, our notice pleading standards change in cases that seem really big or really important or whatnot. And yes, do the defendants have First Amendment values that apply to them that they want to uphold? Yes. The plaintiffs in this lawsuit also have interests to be able to run for office without this kind of rank manipulation of the process, to communicate to voters. I mean, if you want to pull the lens back, I would say you're going to encompass a wide field of view that doesn't just look at the Des Moines Register. It looks at millions of Iowans, hundreds of millions of Americans, people around the world who were, I'll just say, deeply misserved by the conduct and misconduct of these defendants. On the eve, I mean, we all like to say every election is the most important one that we have ever had. I think most people would say the 2024 presidential election was a fork in the road. And there may be many forks ahead, who knows? But to have that lie dropped in the middle of our political process, if the court wants to say, gosh, these seem like big, important issues here, and I have discomfort, then you have to put that on the ledger too. And what all of that says is that this should be aired in a court proceeding, not a court just simply saying, yeah, that was really bad, but I think these media defendants should get a pass. And it doesn't matter what the notice pleading standards are in the state of Iowa. It doesn't matter what the Iowa Supreme Court has said over and over again. I don't like the vibes, therefore case dismissed. That's, Your Honor, I appreciate you asking the question the way you did, but that's not law.
Okay.
So on the question of actual damages, the consumer fraud statute doesn't say you just get the price of your newspaper you bought that day back.
No, but it does tie to the transaction, the damages, correct?
Well, if you're, forgive me for getting my iPad up here.
I mean, so, yeah.
Actual, 714 capital H point 2 sub 1, actual damages means all compensatory damages proximately caused by the prohibited practice or act that are reasonably ascertainable in amount.
Okay.
It excludes non-economic damages, is what the rest of the definition essentially says. Okay, so they have to be pecuniary losses, but it's not. If the legislature wanted to say, a disgorgement of the transaction, a reversal of the transaction, they could have and would have very easily said that.
Okay. No, let me ask you then the question that I posed to Mr. Kleinfeld. Under that statute, okay, back up. Assuming for a second that your clients suffered an economic loss, the pleadings seem to indicate that that economic loss may have run to the campaigns and not to the individuals, and that to the extent that the individuals had any damages, they were non-economic in nature. Am I misreading the pleadings?
I think you're reading it too narrowly, Your Honor, and part of this is the interaction with how both Iowa and federal campaign election law works, and that is if you are a candidate, obviously you run as a natural person, of course, but everything you do through the campaign has to be done through an official campaign committee.
Right.
And I would take the position that that's your legal representative for engaging in the political process.
Are you aware of any case law in Iowa that would define legal representative that expansively? Does it do it in the campaign finance world? I don't know.
Well, in terms of, no, I don't know if anybody's ever litigated that question in the consumer fraud, Iowa consumer fraud.
I'm
Right.
fairly certain they haven't.
I'm doubly fairly certain they haven't. So, but as a question of how election and campaign finance law works, the law says, in effect, you interact with the process through a single committee with the responsible treasurer, all the dollars connected with the campaign effort. There's a couple tiny little nuances to that I'm going to leave off. You know, if you're running for office and spend less than $750, I mean, that don't apply here, okay? So I'm a little nuanced, but basically, everything has to be done through that official committee in how you participate in all the nuts and bolts of running for office. And so there's no additional information in the statute as to what legal representative means or doesn't mean, and I'm sure that'll be an issue that's faced with vigorous motion practice, but I don't think it is just simply President Trump and the other plaintiffs alone simply as like what was in their pocket when the poll dropped. That is a far too narrow view of the scope of damages here.
Humor me for a second. If it were a matter of actual damages suffered by the individual plaintiffs in this case, not the campaigns, where in your petition have you asserted that they have suffered any economic damages?
Well, in the part that you refer to, and because I know how federal and Iowa election law works, I think it's very hard to separate the candidate from the official committee.
Okay.
Because
I'm sure election law does separate the two, though, correct?
well, not really. I mean, you have to have your whole operation within a single committee that you are legally obligated to create and structure and have disclosure requirements, and you can't, I mean, it's hard. You can't do anything outside of that legal representative that you're forced to create to engage in the political process. If you want to spend more than, I think it's $1,000 to run for president, which it costs more than that.
Let me switch gears a little bit. I don't want to take you too much off your presentation, obviously, but I do have questions. Let's talk a little bit about, in the consumer fraud section, what you believe is the consumer transaction in this case that supports that you've pled that it supports this cause of action. What would the consumer transaction be? Is it the purchase of the papers? What is it?
So you've asked that question in a summary way, but I want to go back to what 714H.3 defines a prohibited practice to be. And it's making the false statements in connection with the sale of consumer merchandise.
Okay.
And then we have to show that the damages are caused by that sale.
No, isn't there, I think the case law, and I want to say it's McKee maybe, the case law does indicate, doesn't there have to be some privity between the parties?
That's the Illinois case you're referring to.
Yeah, I
right?
believe so, yes.
You know, that case says that. Whether under these facts, under this definition, and interpreting the statute, a privity relationship would be necessary, I think is an open question.
Wouldn't that then, if there is no privity, we get back to the issue that they brought up in their briefs and Mr. Cornevere referred to, doesn't that open up massive amounts of liability to people like meteorologists, sports commentators, this whole group of folks that are out there giving their opinions based upon their best guess, that somebody goes out and makes a bet based upon, or they plan their wedding based upon a meteorologist? Doesn't that open all of those individuals up for liability?
I don't think so, as proven by the fact that you don't see those cases being brought. But
just because nobody's been brave enough to bring them doesn't mean that they won't come now.
I think the difference is in the type of misrepresentation made with the poll versus what any reasonable person watching the weather would understand as to the zones of uncertainty in what is being forecast, and one's life experiences that the weatherman might say it's going to be sunny, but you should still bring your umbrella, okay? Versus saying we have determined some objective scientific fact, which is just wildly false, okay? And let me give you an example of that, Your Honor, in a different context, okay? And quite frankly, I'm old enough to remember when a former Des Moines Register editor got involved in something very similar to what happened here, okay? The court might recall this. In 1993, NBC News aired a news program about General Motors pickup trucks, claiming that they were defectively designed and would explode in crashes. And they staged for that news program a demonstration test crash where they showed a vehicle striking the pickup truck and it explodes in a ball of flames. Shocking video that they put out. And it was later discovered that NBC News had rigged the truck with pyrotechnics to make the explosion happen. Okay? And I remember what happened to that former Des Moines Register editor. He resigned in the aftermath of all that. NBC paid money and was forced to apologize. Okay? This is creating what is purported to be an objectively true fact. We have measured this population and we have gotten these answers, and that says X.
But, so how can you say it's a fact when it's anticipating something in the future, and in the poll itself, there's a built-in error rate? They're actually saying, this is what we think, and look, we may have this degree of error in it. How is that an objective fact?
Because it is so statistically improbable that that measurement that they claim to have made, and we have to take it at this point on their assertion that they actually called people and actually asked them questions. They didn't just concoct this. That's what discovery will tell us what happened with the polling process. And did so also with the congressional race that was equally wildly off. When I'm confident we're going to learn from the discovery process that every Des Moines Register political reporter would have been telling their editorial team, we don't see that this is Harris +3 in Iowa. What are you talking about? Or words to that effect. And so that's where you get into it is objectively false. It is rigging the truck with explosives.
But doesn't that then go to your additional point of reliance that the defense had brought up? There's no ability, you in your own pleading have spent a fairly significant amount of time talking about how the polls previous to this one were not reliable, and you guys knew about it, and President Trump, immediately after it being released, talked about how it was garbage. So how can you say that you've relied upon this in any way, shape, or form?
Well, I mean, first of all, that reliance issue comes from that Illinois case.
The McKee case, yeah.
Right, and so certainly for purposes of today, I don't think the court can read into a reliance element that we have to plead to Twombly and Iqbal standards.
Okay.
Right? And this may be a good example of why courts should just look at what the statute says and not add elements to it. Now, we have to show causation. We understand that for damages. But, I'll go back to the example I just gave you there. Right, obviously GM would not have been relying on NBC News in that situation. What you have is a news organization creating a lie, and then people damaged terribly trying to deal with the consequences of that 3 days before Election Day. Did you have, Your Honor, have any other questions?
No,
I had
don't.
one more thought that I wanted to end on.
Go ahead.
And I want to respond to my friend, Mr. Korn-Revere's comment, first of all, raised in a reply brief, which is not where you bring up new ideas.
Okay.
So, and he brought it up again today that somehow the court should sua sponte issue sanctions to us or issue an order, show cause, or whatnot. We discussed this thoroughly at the last hearing. The Iowa Supreme Court Shearer case is quite recent and explains lawyers are allowed to bring novel claims. As Mr. Kleinfeld says, this is a novel claim. You're right. We are allowed to do that. We are allowed to ask the court to revisit prior doctrine. We are allowed to ask the court to find that the Illinois case in reliance is not applicable here. We're allowed to do all of those things. Now, I will remind my friend that he appears in this courthouse admitted pro hac vice, and he is obligated to act like an Iowa lawyer when he does that. And I don't want to be in a position where I have to ask this court to revoke that admission because he is not acting like an Iowa lawyer would act. And I hope this is the last time we hear about this. With that, Your Honor, we'd ask the court to deny the motions. Thank you.
Thank you very much. We appreciate it. And with that, I'll turn back. I guess I'll just loop back around. Mr. Korn-Revere, if you would like to give any rebuttal.
juggling a few
Take your time. You may proceed.
Thank you, Your Honor. Just a few points in rebuttal. I want to start with the point that Mr. Osgood first brought up, talking about how the anti-SLAPP standard doesn't apply in this case. We would agree that it doesn't, but it's something that the court can take into consideration. But in making that argument, Mr. Osgood fundamentally misstated what the anti-SLAPP law does. He made the argument that it didn't repeal notice pleading, it simply set special rules for discovery and special summary judgment. In fact, what the anti-SLAPP law does is create a motion for special expedited relief. It says a person against whom a civil claim is filed may file a special motion to dismiss based on this act. The motion stays discovery and requires the court to conduct a hearing within 60 days of filing. Now, he found it interesting that we're arguing that that law was necessary if you can dismiss on a simple motion to dismiss. And the fact is, states around the country, and now Iowa, have passed these anti-SLAPP laws to make it absolutely clear that those special rules do apply. But that doesn't give a pass in a notice pleading case state that does not have an anti-SLAPP law to accept deficient legal claims. They are still barred under anti-SLAPP principles. In terms of notice pleading, we cited a number of cases in our reply brief that talk about notice pleading and dismissals that were appropriate specifically at the motion to dismiss stage. For example, White versus Harkrider dismissed 6 out of the 6 claims, only 1 survived. And the Iowa Supreme Court said in that case that dismissal is proper when the petition shows the claim or claims are legally deficient and the plaintiff has no right to recover as a matter of law. Now, in fact, the plaintiffs did cite the White case in their papers and cited the dictum in the dissent that said that dismissals should be rare under notice pleading, but ignored the holding of the case, that where the claims, in that case there were some constitutional claims and some tort claims, where they were deficient, the court dismissed the claims. And as a matter of fact, where the district court had not dismissed claims on appeal, those dismissals of those failures to dismiss were overruled because they should have been dismissed. Or you could look to Bowick versus Kawasaki Motors Corporation, where the Iowa Supreme Court said that notice pleading does not create a duty where it otherwise would not exist. And Schmidt versus Mahoney on that same theme said that a case must be dismissed where there is an absence of legal duty that precludes recovery, as here. Shoemate versus Drake University. It does not create a private statutory remedy where a case must be dismissed where there is no private statutory remedy that the legislature provided. Or Smith versus State. Notice pleading doesn't allow you to invent an unrecognizable tort. I could go on with these, but we cited, I think, 19 Iowa cases dismissing claims in whole or in part in our papers. What you get from the plaintiffs are citations to dictum, sometimes in dissent, saying that it should be rare to grant dismissals. Well, maybe it should be rare, but where you don't have an actual claim, notice that dismissal is required. And in Kingsway versus Cathedral versus Iowa Department of Transportation, the Supreme Court said, where the petition's own allegations show no legal right to relief, the court must dismiss those claims. So contrary to what you hear from the plaintiffs, dismissal is required, and that includes claims for fraud. So, for example, we cited Postal Finance Company versus Langdon, where the Iowa Supreme Court affirmed a dismissal and explained that to call a thing fraud without a statement of facts constituting fraud is not an issuable allegation. And so that's the argument we've been making. Mr. Ostergren says we've been trying to rely on federal standards. That simply isn't the case. We cited the Iowa law in our brief, acting like an Iowa lawyer, and we found that, you know, the basis for dismissal is palpable here. The third thing is that listening to Mr. Ostergren talk about the basis of the claim, what they would find in discovery, what facts would make it necessary for this case to go on, all of them are geared toward saying that we will find out just how wrong this poll was. We'll find out how it was manipulated and all of that. When the very premise of our motion is, even if you accept the conspiracy theories, even if you accept the wildest allegations that these people are willing to make, there is no claim here, none that can be recognized and go forward. And it doesn't matter how much discovery you were to allow, or how many ways they'd want to amend their complaint. You can't fix what is irrevocably broken. A good example of that, looking at just the First Amendment factors, is a case that we cited in our reply, Blatty versus the New York Times. That was a case where an author had sued the New York Times for trade libel, among other things, because he was upset that the New York Times excluded him from its bestseller list. And the allegation was made that that injured him because he didn't get the respect that he was due. The problem was his pleadings didn't include the necessary elements to make a libel claim. One of the necessary elements is that someone has to issue a statement, a false statement, of and concerning the plaintiff. The problem in that case is there was no statement. The plaintiff wanted the New York Times to talk about him, and that was the basis of his claim. California Supreme Court upheld the dismissal and said that it was absolutely barred under the First Amendment because the basic elements of the case could not be made. And the same is true here, where no matter how false Mr. Ostergren has convinced himself the poll is, or how nefarious the motives behind it, it simply is not a claim that would be recognized under the First Amendment. Again, Mr. Ostergren tries to rely on a commercial speech doctrine, but again, even fuzzes that up, because commercial speech, even if you accept that that were the doctrine that applies, and it doesn't mean that speech is unprotected by the First Amendment. He would still have to make his fraud claim separately, and it simply doesn't apply. You may recall that I asked Mr. Ostergren to cite his best case for the principle, and I'm still waiting for that case. There simply isn't one. Your Honor had asked earlier about discovery networks and whether or not that could stand for the proposition that the commercial speech doctrine might apply here. And if you read the rest of the quotes beyond the ones that you just see in the plaintiff's papers, the Supreme Court says we begin with several propositions that are already settled beyond serious dispute. It is clear, for example, that speech does not lose its First Amendment protection because money is spent to project it, as in a paid advertisement or advertisement form or another. Speech is likewise protected, even though it is carried in a form that is sold for profit. So, none of these arguments add up to any kind of cognizable claim. And again, everything that Mr. Ostergren was saying was just how bad he thinks this poll is. But the point is, that doesn't make it fall into a category of unprotected speech. And that was the point the Eighth Circuit drove home in the Arneson cases, saying that even in the political context, even where people may rely on statements being made, you simply cannot, under the First Amendment, make it an offense, either under the criminal law or at civil law, to tell a lie in a political campaign context. We also cited at page 13 of our motion various states that have had laws that attempted to do that kind of thing, all struck down. In Massachusetts, North Carolina, Ohio, Massachusetts, and Washington. All of those states regulating the very interests that Mr. Osterrian has been trying to champion, all not allowed to go forward. And that is the problem of trying to mix and match various doctrines. The problem of trying to create claims where they don't otherwise exist. There simply isn't a recognized category of First Amendment speech that courts would allow a claim like this. Like I say, I asked Mr. Ostergren to name his case, and he really has come up with nothing. And what you find are isolated statements from a handful of cases saying that falsity isn't protected. As I've noted and we discuss at length in our briefs, that's true only in specific contexts. In the defamation context, and this isn't a defamation case. It's true in the fraud context, and for all of the reasons that we've laid out, it doesn't meet the elements of fraud, which are constitutionally required according to both Madigan and Alvarez. None of this adds up to a coherent theory. In Alvarez, the court explained that you can't take statements out of one area of free speech law, plug them into another, and make them apply. And Arneson specifically said that fraud principles, that it rejected the government's attempt to apply fraud principles to all knowingly false speech in the electoral context. Your Honor, we just received a decision this week, and I apologize we didn't have a chance to cite it in our papers because it only came out on Tuesday. But it's a decision not on these issues specifically, but on just general First Amendment theory, this time in protecting university speech. The case is Purnell versus Florida Board of Governors of the state university, and that involved a state's attempt to control the curriculum in the state. The court castigated the state for pulling various quotes from doctrinally unrelated areas, and it said this: Florida seeks to evade any First Amendment limitations at all by rigging together several speech doctrines to create a new rule that would quietly remove all free speech protections from the classroom. The Florida defendants cannot put together half a donkey and half a camel and then ride to victory on the synthetic hybrid. That's exactly what's going on here. That's why plaintiffs have not been able to name a single case that would support their theory. That's why they have not responded at all to the various attempts that have been made to bring fraud claims against against news organizations because they simply don't make out claims that fall into any of the recognized exceptions. Finally, let me just address the issue of sanctions. Because again, Mr. Ostergren has said that I'm, as he put it at the stay hearing, waving the bloody shirt, talking about sanctions. It's interesting because the origin of that expression, waving the bloody shirt, comes from a congressman from the 1870s, Congressman Benjamin Butler. And the expression came from when he would constantly, when he wanted to support a weak political argument, talk about all of the sacrifices of our Union soldiers. And so he would wave a bloody shirt, or I don't know if he did that figuratively or literally, to try and cover up the weakness of his claims. And that more or less describes the nature of this case. We hear lots about fake polls and all of that, when in fact, the plain fact is there is no legal argument to be made here. And that's the whole point of raising the question of whether or not professional responsibilities have been met in this case. This isn't something that just came up to us in a reply brief, as Mr. Osgren suggests. This is something we've been asking for from the day this case was filed. And in fact, before the day this case was filed, because we asked the same question when this case was in federal court. We made the point in our motion that they have made no argument for extending the law. They're simply ignoring the legal arguments. They've not even acknowledged what the existing law is, let alone made an argument to change the law. And that's something that we pointed out in a reply brief, saying they still haven't come up with a case. And if you want authority from Iowa on that point, Barnhill versus the Iowa District Court for Polk County, which I mentioned earlier, is the correct authority, where it not only says that there is an obligation to acknowledge the existing law and to try and provide some response to it, but it also upholds sanctions when someone tried to make a claim for negligent misrepresentation where there was no duty between the parties, just as there is here. So again, I'm not asking for sanctions, but I would like an explanation, and I think the court is in a good position to demand one.
Thank you. Thank you very much. I appreciate it. With that, I'll turn to you, Mr. Kleinfeld, for the last word.
Thank you, Your Honor. I'll be brief. First, to address the novelty of this case, unfortunately, it's novel in the sense that it's being brought by the President of the United States against the state's largest newspaper, but it's not novel in the sense of politicians attempting to intimidate the media in our history. That happens, unfortunately. And there's been case law, and I think Mr. Cornevere has cited much of it, that has dealt with that. The other thing I want to say about the First Amendment is really two things. One, I think we need to take a step back and realize that this is a fraud case based on political speech. That's a problem. That's unconstitutional. You can't do that. Iowa's notice pleading standard does not supersede the Constitution. This is not commercial speech. And even if plaintiffs want to turn that page and go down that road, they've said nothing about this being limited solely to a proposal for a consumer transaction.
Let me ask you this, Mr. Kleinfeld, before we get too far down. Does the fact that, as Mr. Ostergren has argued, that they're alleging that there's manufactured data or non-existing data, does that, and at this juncture, I assume I have to take that at face value, I have to assume that allegation. Does that affect the analysis at all with the state claims?
Absolutely not.
Okay.
It does not turn the Iowa poll into a proposal for a consumer transaction. It does not magically create a consumer transaction. It simply doesn't matter. I want to address briefly a couple of questions that Your Honor asked my colleague. One specifically was on ICFA damages, and I just wanted to see if I could help out on that issue. And the question was twofold. One, plaintiff's counsel seems to be indicating that all pecuniary damages are available under ICFA. He doesn't, in other words, he doesn't deny that the damages they're asking for are in the nature of mitigation or consequential damages. He's saying that those are provided for in ICFA. They're not. The law is clear on that. It's actual damages. The court knows what actual damages are. It's defined. That's a legal dispute. It's not a summary judgment dispute where you're talking about how much damages are. This is the nature of damages. That's just not.
It's actual damages and excluding non-economic damages too, correct?
Correct, absolutely. And that's an excellent point, Your Honor. The second brief point I wanted to touch on that is there's a question about legal rep and campaigns, and what the statute actually says is legal representative of a natural person. All the statute's talking about, and Your Honor's probably been through this before, is they're talking about a legal representative for a minor or a decedent. They're not talking about a legal representative for a separate legal entity like a campaign, or certainly not a business.
Or an agent.
Or an agent, exactly. Next, Your Honor asked about consumer transaction. And again, this exemplifies why we're talking about a motion to dismiss here, in that plaintiff's counsel does not say there's going to be a consumer transaction, that there was a consumer transaction, or that discovery could produce one, saying it's not required. That's a legal dispute. It absolutely is required. We rest on a brief there. But if it wasn't required, again, you just have a freestanding grievance statute. But that's the legal dispute, whether or not that's required. Not what the facts show or could show, but whether it's required. Lastly, Your Honor had asked about what discovery plaintiffs could anticipate would change their case. And the answer is, well, how the poll was conducted, whether it was conducted at all, the process in which it was conducted, what the participants knew or understood. What it would not change is it would not turn the Iowa poll into a proposal for a consumer transaction. It would not demonstrate that there was a consumer transaction. It would not demonstrate that there was reliance on the accuracy or truth of the poll to enter into a consumer transaction. It would not establish legally cognizable damages. At the end of the day, Your Honor, I think what we've all collectively demonstrated to you today is that there's no conceivable set of facts that could make out a legally viable claim here. Thank you.
Thank you very much. Thank you, folks. I appreciate the presentation. Obviously, you've given me a lot to think about and a lot to plow through. I'll get you out an order on this as soon as possible. It is going to take several weeks, I'll be honest with you. I've got a number of other rulings I've got to dispose of before I'm able to handle this one in earnest. So please bear with me on that end. I will get you out, though, as soon as I can, an order. I will tell you it will unlikely be as long as your briefing. But I'll get you out one as soon as possible. Thank you so much for your time, and we'll go ahead and go off the record. Have a good day, folks.
Good to see you. Nicely done. Yeah. Tell Ed I'm sorry I didn't get to say hi to him before he had to jet.
Sorry.
I think we are on that piece of paper.
Yeah.